Welcome to the official Lawyer Minds podcast. Lawyer Minds is an ever-growing ecosystem for all the resources modern lawyers need. As the official Lawyer Minds podcast, we'll discuss everything from the latest happenings on the website to industry news. Get ready. Here we go. It's time to dive into the minds of successful lawyers. Here are your hosts, Tad Thomas and Mike Campbell.
Mike, what's your favorite deposition objection?
Oh, relevance. That's my favorite one by far.
Objection relevance. What were you asking about in an airline crash case and a trucking case or something?
It was, I get them actually more regularly than you would think, but it's always something that you just kind of shake your head internally, I guess, and just keep going.
Mine's facts not in evidence.
Yeah, that's a good one too.
Yeah. Isn't that the purpose of the deposition, to get the facts to enter into evidence?
Yeah, or just objection to form.
Yeah, it's I've got one deposition from a long time ago, a transcript where it was virtually every question with the exception of state your name for the record, that the defense attorney said he objected to the form. The entire deposition. And back then I was too young and experienced. I really didn't know. I ignored him just because I didn't know what else to do. And I think when we talk to Mark Kosieradzki in a little bit, he's going to tell you ignoring them is one of the best things you can do because it just drives them nuts. But as I've gotten, older, I've learned that, objection to the form is a proper objection, but then they have to be able to articulate to you what's the problem with your form, because the whole purpose of having that objection is so that you can correct it at the time of the deposition. So I remember it's just not too long ago, a younger attorney, I objected to the form of the question. She had obviously been taught by one of these lawyers that objects to everything. Objected to the form of the question, and I looked at her and I said, okay, explain to me what the problem is with my form. And she said, I don't have to tell you that. And I said, well, actually you do. And that's kind of part of the rules. And that's why it's a proper objection, so that I can fix it. And then her next statement was, well, can you read it back? You read back the question to the court reporter. And of course there was nothing wrong with my question. She couldn't articulate why she objected. And we went on.
And then you go to the other end of the spectrum and they say objection to the form, misleading, vague, misstates previous testimony, argumentative, harassment, and they list everything.
The objections where the objection is a page and a half long.
And it's like, hey man, what's the deal? I mean, if I have a question about it, if I'm thinking, well, actually I know when I ask a bad question or a compound question, I'm like, that is a terrible question. Let me restate that,
Right.
But you can't ask them, or you have to ask them to clarify, because you can't go back and fix it.
Right. Exactly. And, one of the things that I love about, AAJ education specifically, but, helping out other lawyers with stuff like this and having the benefit of other lawyers teaching me, the rules and not just knowing the rules, but how to handle yourself and, the right way and wrong way to do things in a deposition or in trial. And, one of my favorite speakers that I've ever seen has always been Mark Kosieradzki. So it's really a pleasure to have him on the podcast today and to listen to him talk about some of the work that he's done on abusive deposition techniques, as well as 30B6.
Yeah, I mean, absolutely. And I think that you hit the nail on the head, because there's it's one thing to know the rules, but then it's another thing to see guys who you admire and know are crushing it, for lack of a better phrase, that are doing so professionally, they're doing so calmly, and they're not out there beating their chest in a deposition and acting like an insane person.
Yeah. And Mark, like with 30B6, just knowing the rule and the case law sometimes isn't enough. I remember I had seen Mark talk about 30B6 depositions, 2 or 3 times, and, gone to his hour-long seminars. I hadn't gone to one of the day and a half ones that he puts on now, but it was an hour seminar. So I'd seen him a couple times, read his articles and things like that. That was before the book. But it wasn't until I actually brought him in to work with me on a nursing home case, and we really got to put this stuff into practice that I really understood how it worked, because, you know, he'd send me the form and then I'd sit with him in the deposition and he'd explain, this is why I do it this way. This is why I do it that way. And I learned so much by co-counseling with someone who knew the stuff better than I did.
And, you know, one of the things that concerns me is not necessarily the fact that there's not enough advice out there for lawyers to learn from. It's that there might be too much, and you kind of have to figure out what advice you want to take. And working with a guy like Mark is, you know, I can't imagine the experience that you have, but this is a guy who has spent his whole career, you know, mastering and specializing in this one skill, which is depositions. Now, he's had great success trying cases, but, you know, he knows everything about depositions, and he knows everything about handling obstruction and 30B6. And so I'm excited not only to hear from him, but to know that he's one of those guys whose advice you should follow.
You know, one of my favorite things about Mark is one of his sayings is, I hate the phrase outside the box. My response always is, what box? That's clearly the way Mark thinks. And if you know Mark personally, you know he doesn't do anything halfway. He's 110% on everything. So let's go ahead and hear from Mark Kosieradzki. Mark, thanks for joining us on the podcast. I appreciate it.
Thank you for having me, Tad.
So, you know, whenever I go to AJ, I always get new lawyers come up to me and they ask who they ought to go see speak. And I always make sure to have them go see you. And I tell them it doesn't matter what topic you're talking about. And also plug their ears at the very end, because they always break out the recorder and surprise everybody. You got it with you?
No, Monica, there it is.
Never go too far.
Ready to go.
Mark, I want to talk to you. You know, you've written a couple of books already. You wrote a book on 30B6 and a book on deposition obstruction. And I know you were one of the original founding faculty members of the AAJ Depositions College. Why don't you talk to us about Depo College first?
Well, it started in Colorado. It must have been like 25 years ago. And the idea was, you know, there are all these trial skill schools everywhere, but not that many cases go to trial. And depositions are where the rubber meets the road. So they thought, what a great idea for a CLE. And of course, Philip Miller and Paul Scopter and I were just thinking, well, what are we going to talk for multiple days on depositions on? But we had these brainstorming sessions, and started breaking down depositions into their component parts. And we started saying, man, there's a lot of interesting ideas here. And there's a lot of techniques and strategy that go well beyond who, what, where, when, and why. And it's how you develop that information is really something that we ought to be thinking about. And, you know, through this process, we ended up realizing that depositions are trial. The sound bites, the video clips, the information you get are the evidence you need for trial. And if you can get it at the deposition, then you are ready to go for trial.
And, you know, part of that, I guess we've always done a deposition obstruction was, you know, one of the CLEs included in Depo College. But what made you decide to write an entire book on deposition obstruction?
Well, I've dealt with obstruction ever since my first deposition. And back then, nobody would train you. They just throw you in, and you actually think that that's the way you're supposed to behave, because that's what your adversaries did. And you never saw anybody other than your adversaries. And it was frustrating, and the old lawyers would pick on the young lawyers or on anybody that they perceived as weak. And through the Deposition College, way back when, a case called Hall versus Clifton came down. And it was kind of a revolutionary look at how depositions should work. So I was asked to teach that case. And the more I started studying the case, and the more I started teaching it, and the more I started implementing it into my day-to-day practice, the better my depositions got, And that my stress levels went down on the depositions.
So I think, go ahead, Mike.
Oh, I was just going to ask, you talked about your experience. I don't think that that's changed too much for newer lawyers, the fright or the fear that they might have in going into a deposition where they know someone on the other side might start picking on them. What advice would you have for a newer lawyer that may be going into their first, second, third deposition and has that fear?
Object to the form.
First advice is know the rules of engagement. And people say, well, judges don't enforce those rules. Well, actually they do if you follow the techniques we talk about. So if you know the rules of engagement, then the next thing you need to do is get a good night's sleep and go in knowing the rules and don't get sucked into the vortex. You see, what happens is everybody thinks they got to beat their chest and show how strong they are because they're alphas and they're not going to get pushed around. And what the most new lawyers, and frankly, many experienced lawyers don't really recognize is we're playing chess, not checkers. It's not just in who you can take at any given moment. It's the long end game. And the techniques we teach at the Deposition College and the techniques I teach in the book are how you keep your cool and you do what I call litigation jujitsu. You flip their obstruction back onto them. And if you know what the rules are and you just ignore them, you literally ignore your adversary, it's kind of this passive aggressive thing, and they get angry. And then they object more, and they object more. And that one depo may get, be dirty and screwed up. But what we recommend is just sit on your hands, don't engage, don't get sucked into the vortex, and then have a picture in your mind of a pie chart that shows 48% of the deposition is a defense lawyer talking. And have in your mind a picture of copies of the transcript with the defense lawyer or whoever is opposing you. Every time they talk, you highlight it. So it's this colored thing. And when the judges see what's going on, they do enforce the rules. What they don't do is get involved if you get into a pissing contest. And as we used to say back in Iowa when I grew up, you don't get into a pissing contest with a skunk.
Yep, that's exactly right. I will say real quickly that when I went to the Depo College, up until that point in time, I thought maybe I needed to shake it up a little bit to show kind of, that I was not going to take it. And then I listened to guys like Chris O'Brien or like Tad and realized, oh, I can just be myself and just let them do whatever if they want to be a jackass, they can be a jackass. I don't have to be a jackass back.
So exactly, because when judges get angry because they think lawyers are acting unprofessional and they're like children in a sandbox getting in a fight. And one side, if you get sucked into the vortex, no matter how good you think you sound, you don't sound good. So really, the only comment that I think is appropriate to say is when there's one of those speaking objections where they're coaching and doing speeches, is say, please don't make suggestive comments in front of the witness. Please is the magic word your mother taught you. It reads well. If that's all you say, that's a meet and confer, and they know what you're doing. But just don't get into arguing law. Don't get into arguing anything. Just let them hang themselves. And I'll tell you, it works. I mean, I've got lawyers who never object now, who just stay out of the way. And I remember they said, Mark, you're just trying to set me up for a sanction. So I'm not setting you up for anything. I'm just letting you do what you do.
Perfect.
One of the things I guess I didn't know as a young lawyer and probably didn't realize until Depo College was, why certain objections were appropriate at the time and certain ones weren't. And you have the lawyers that object to the form on every question. And I didn't realize until I listened to your lecture way back when that, well, you can ask them, what's the problem with your form?
Right.
And they're not used to that. And, they're so used to doing it. The first question out of their mind is to the court reporter, well, can you read back the question? Because they have no idea what they object to.
You're absolutely right. So let's take a step back and say, what are the questions, or what are the rules we should be thinking about? And if you're thinking about, is their conduct appropriate, or if you're asking the questions, are your questions appropriate? And you look through two lenses. The first lens is this something that can be done in court? Because the rule goes right to it. The rule says that depositions are to be conducted just like a trial. So is this something you could do in front of a judge and a jury? Or is this something your adversary could do in front of a judge and a jury? Long speeches would not go very long in front of a jury. Instructing a witness not to answer because you didn't like the question isn't going to go very far in front of a jury. So, and yelling and screaming is not going to go very far in front of a jury. Or an objection where you say objection, irrelevant, and then have an explanation why it's irrelevant. You can't do that in front of a jury. And as long as you understand what you can do in the courtroom, you know what you can do in the deposition. Now, the exception to that is the other lens. Can it be fixed? Is there a defect in the way the question is being asked that could be corrected at the time? That's an objection that has to be made. Form and foundation are the two technical ones. But frankly, form is what? Argumentative, compound. As you say, well, it's leading. Well, if you're taking the deposition of an adversary, you can ask leading questions. And so that's not a real legitimate question. Foundation might be, because the rules of evidence require a fact witness to be able to speak about what they have personal knowledge of, and an expert to speak on what they have sufficient information to base their opinions on. But what you raised, Tad, was there are some lawyers who just do it to try to break up your depo. And I had a deposition in Tulsa on a med mal case I was doing down there last year, where I was 2 questions in, and then after that, every single question was objected to as form. And I just ignored it, and they finally went away. But if it's one that you actually think is just a perfect question, ask what is wrong with the form so I can correct it. They'll either say, for me to know and you to find out, and that'll get a sanction with the court, or they go, whoa, 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 whoa. And it's not a form objection. And that's a good way to clip their ears back. But you don't want to do it every time. You want to hold it for when you know there's just nothing they can ask about. I mean, I actually had one in Chicago on a case where I said, please state your name. And they go, objection, vague, first or last.
Be serious. Wow.
That's the honest to God truth.
Perfect.
And that's when I started learning that you have to learn the rules.
I always think it's funny when you have a younger lawyer on the other side who's been taught by one of these attorneys that obstructs, and they're objecting to the form all the time. And then, once you ask them, okay, well, what's the problem with my form? And they don't know and they can't respond, then they just stop objecting to the form. And I found that a way to stop them.
One thing that I like to do, because I'm always playing the long game, and my cases tend to have multiple depositions, or I have cases that have the same defense lawyers over and over again. So you need to just kind of teach them early on. So after, I just keep saying, please don't make suggestive comments in the presence of the witness. At the end of that deposition, that night, I'll send him an email. Dear Joe, I'm writing in the first step in the meet and confer process about my concerns with the disruptions of the deposition I took today. I'm not saying you did it in bad faith, but a lot of people don't know the law. And so here are the issues I see. And then for each one, I'd have like a black bar, speaking objection, or, answer if you can. And then I literally pull the paragraph out of my 30B6 or out of my deposition obstruction book and put it underneath that. And then, and I don't even have the count yet. So I said, I'd like you to take a look at these cases and let me know if I misread them. Or if you have any authority to the contrary, share it with me so we can decide what are the appropriate rules of conduct in the deposition. And if we can't, we can have a judge resolve it. And just to make it easier, I've attached a stipulation for entry of order of deposition protocol laying out all of these principles that I'd ask that you sign. Now, I've never had anyone sign it. But here's what happens. Once you've given them that, they can't say they don't know the rules. Mm-hmm. And once you've asked them to give you the law, they can't, because there is no law contrary to this. Then in the next deposition, you give them 1, 2, 3 objections and say, I think we're going to have to recess and get a motion for deposition obstruction sanctions. And now you've got the first one with all the highlighting and the second one, and now you've made this record of how professional you can be. Now, I've had a fair number of lawyers who will back off and get much better. They'll still object a little bit, but it won't be the constant disruption. You don't want to go to the court with 3 or 5 or even 10 bad objections. You want to have a huge record, 400 lines underlined, or a pie graph of 30-40% of the transcript. And I will tell you, judges, there are judges who've sanctioned $20,000. I mean, Pat Malone used my book recently and got something like a $40,000 or $50,000 sanction in Maryland, in Washington, D.C. for deposition obstruction.
And isn't part of it that, defense lawyers or lawyers on the other side that are engaging in these tactics, they're expecting you to roll over and not do anything and just sit and take it or get into a pissing match. They're not expecting you to actually file a motion with the law and citing the cases.
Right. And in fairness, both sides do this a lot.
Yeah.
But we're doing it less and less because you and AAJ have been working really hard to advocate for professionalism and following the rules. And as our people are doing it less and less, more and more motions are being brought because their hands are clean. There was just another big one in New Orleans about a month ago. There was a big one in Alabama about a month ago. And the judges, when they see this record, they get irritated. The brief doesn't have to be long. The brief says, the opening line is, before the court is a motion for reconvening the deposition, admonishment of counsel, and such economic sanctions as the court sees fit. First sentence, judge knows what the case is about. Second sentence is depositions to proceed as trial. In this case, and now you have each category, there were 97 speaking objections, 42 instructions not to answer, 19 clarifications of the questions, 2 off-the-record conferences that were insisted upon by counsel, and you have this list. Then you go to the book and you literally have just those paragraphs, and then you have the transcript highlighted. The brief's 4 pages long at max, and it works.
And I think, for me, it's liberating. You talked about it. The deposition is supposed to be run like you're at trial. It's liberating for me to know that as long as I know the rules, all I'm doing is addressing the court whenever I am saying something like, this is the rule that governs this specific issue, because the other side wants me to mix it up with them. If I can just remind myself, I'm addressing the court, not you personally. This is not a personal affair. This is me being a professional.
And I agree, but I don't even do it at the depot. I'm addressing the court at the trial, or
right.
at the hearing, because I just want to keep moving forward.
Makes sense. That's exactly right. Yep.
I mean, the minute you start telling them the law, say, you don't have to tell me what the law is. I know what the law is.
Sure.
And they're trying to strut their stuff in front of their clients, and they don't want to be embarrassed in front of their clients. So then they get even worse. But I used to give them the rules, but then the judge said in one hearing on this is, lawyers are presumed to know the rules. You don't need to teach them.
Sure.
And so that behavior changes. And like locally, I don't get it very much. When I go into a new state, the first deposition, I get it all the time. But it doesn't take long for them to figure out what I'm doing. And I'll tell you, if you don't engage with them, the stress level goes down and your stomach doesn't burn and you don't get as angry. And but the only way that's going to work is if you know that you're going to call them out at it that night, and then you know that you're going to get a hearing if they do it again. And they don't want to, and when you put in that transcript that's colored, I mean, I've had them object to saying, well, this isn't a true record, it's highlighted. Really? I mean, it's a visual that is so powerful. I mean, when I give my lecture, I show a picture of the transcript page after page after page that's highlighted. And the judges will look at it and say, they won't even read all the questions. Now, if you have like one on one page and 119 pages later and 300 pages, the judges don't get ramped up about that. You need the totality of the conduct to get them.
So talking about rules, you wrote another book on 30B6, which after hearing you speak and learning from you is one of my favorite rules now. What made you write a book on 30B6?
Well, that just started out as my friend, Paul Scopper and Philip Miller wrote a book on advanced depositions. And Paul said, 30B6 is a deposition we take a lot, and you've been teaching it for a year. Will you write a short sequel to our book for it? I said, well, sure. That'll take, be 80 pages. I'll get it done in a couple of months. Well, 4.5 years later, 500 pages and 900 footnotes later, the book came out. It seems to have been pretty revolutionary because everybody started doing it. And the next thing I know, the defense industry in a lot of tort cases was now trying to change the rule. And we testified before the Federal Rules Committee. It went through a 4-year process, and the Rules Committee did a great job trying to keep a balance of, stopping corporations from just banding and hiding information, and not having a rule that would be, overburdensome. And they balanced it really well. And the 16 proposals that were advanced to totally eviscerate the rules were not accepted. And there was a rule change that said every 30B6 deposition is going to need to have a meet and confer conference about the notice before the deposition is taken. But it didn't change who has to bring the motions. And so I thought that's a good reason to write the second edition. So I started tootling around with it. And then we had this thing called the pandemic that came around. And we closed our office actually 12 weeks ago. So I've been writing for the last 12 weeks, and we have now got 200 new cases, an analysis of every rule change that was rejected, an analysis of every rule. The new rule, me and the Lord, I guess, have expanded the chapter on objections. So we have a deep analysis of proportionality and what is proportional and what isn't. I've developed the foundation depot that replaces the old Death Star because there's some rule changes post 2015 that came into play. So it's got 4 more chapters. It really goes deep into the 2015 changes. It goes deep into the December 1st, 2020 changes. And it really deals very heavily with the 26B1 portion of the rule that says we can find out about what kind of discovery is out there. And I've laid out a whole chapter on how to preempt objections before you even make a request. And let me tell you, that streamlines things like crazy.
Let me ask you this, Mark. As a lawyer who considers routines and formulas like a security blanket, what would you tell me if I came to you and said, should I continue sending out these discovery requests, or should I immediately do the Death Star? Tell me why I should do what you suggest, which is immediately set the deposition.
Well, the Death Star was one where we asked for the foundation for the depots and asked for the documents simultaneously. Mm-hmm. A lot of courts ask that, and then it would ask us to talk, and we would ask them how they found the documents. Some courts started calling that, process-based discovery or discovery about discovery. So the new approach is to do what Rule 26B1 talked about in the comments to the rule, is saying, try to identify what documents are out there before you ask for them. Try to identify the purpose of them to make sure they're relevant. Try to find out how they're shared back and forth so you can determine if they legitimately are confidential or not. Find out where they're located, and then find out not how they would search for them, but what are the different ways you can search for them. So what you do is you do your Rule 34 document request or your ESI request first, but you don't serve it because you know what's going to happen the minute you serve it. Vague, ambiguous, irrelevant, overburdensome. You've got bad breath and hangnails, and I don't like your question, and rule against perpetuities.
Yeah, everything.
And they do it to everything. And then you've got to go through 25 meet and confer letters, Well, what you do is, in your rather than asking for the documents, you say, we're going to ask about these things I just talked about this schedule of documents, which happens to mirror your Rule 34 request. So you ask for, say, when I use this term, personnel file, what kind of documents, does your company have personnel files? What are they called? HR file, personnel file? Do they have different terms? What's in them? Why do you keep these kinds of files? Where do you keep them? If a court told you you had to look for them, what would be the different ways you could look for them? And through there, you can ask them, what's the purpose? Or, an example I use is in a nursing home case, a certain kind of charting, a certain kind of piece of information they're looking for. And you say, where are they located? On my computer. Do you use them? Yeah, I use them every day in my practice. Use them every day to care for patients like my client? Yes. Why do you use it? You've established relevance. How do you find them? Well, I go to the keyboard. What do? I type in 8 characters. Is it overburdensome to type in those 8 characters? Well, no, I do it all the time. And can you print it? Sure. How do you print it? I click print with the mouse. Is that overburdensome? No. When I use this term, patient census, what does it mean to you? Is there anything vague about that term? No. Well, now I've gotten rid of vagueness, relevance, overburdensome, and now as I walk out the deposition, I pick up my phone, I call my office and say, serve it. 30 days later, I get all the boilerplate objections. Now in my meet and confer letter, I can say, I'm calling your attention to page 27 of your deposition, where you said it's not vague, it's not overburdensome. I'm asking you to withdraw the objection. No, I won't do it. Okay, we go to the court. Now the court's got a record and they've got a spurious objection, which in my new Rule 30b-6 book, you will learn in, I believe, chapter 8, that lawyers have an obligation to sign the discovery and verify that the objections are not spurious, that they're valid, and that they have a duty not to rely on their clients, but to verify that the information that is being produced is complete, or verify that it can't be complete, and it is sanctionable upon them, the lawyer, if they sign it falsely.
So Mark, when's the next book coming out?
November 20th. AAJ is doing a 2-day 30b-6 program. It's at the publishers then, and it's going to be launched 10 days before the rule change. So everybody's going to have an opportunity to be up to speed and up and running full speed before the rule changes.
Great. And we'll put some links in the show notes, AAJ Depot College, as well as to your seminar coming up and where they can find it. It probably won't be posted yet, but we'll make sure that everybody knows where to find the book and find your lecture. So
fabulous.
Mark, thank you so much for joining us. Really appreciate it.
Thank you for having me. Ready?
See you, Mark.
Love it.
Thank you, my friend.
Love it. Thank you.
Beautiful.
I want to learn how to play an instrument, Mike.
Which one?
I don't know.
Anyone?
Oz has his, and I've seen a friend of mine in St. Louis plays guitar. I think I need a stick for my CLE.
What about banjo? I have a banjo in my closet. I was supposed to learn how to play it, and I never did.
Tad, the banjo playing lawyer from Kentucky. I think that's too stereotypical.
Well, what about you do the banjo and I'll do spoons?
There you go.
We'll do it.
We'll teach the CLE.
No, that's exactly right. We'll do a traveling CLE where we go, and I'll just play the spoons, lead into you. You just jam out the banjo and teach them.
Well, I wish I could be as smart as Kaz and teach some of the stuff that he's teaching, and
don't we all?
The books that he's writing. I'm real excited about the update to the 30b-6 book he's got coming out.
Yeah, I was reading something yesterday, and it was talking about how you may not have a mentor. The mentor you do have is not a great one. Well, guess what? You have an unlimited resource in looking into books, especially those written by guys like Cods, who just dominate when it comes to this topic.
Yeah, there's books out there that I think aren't worth the paper they're printed on, and some CLE articles that are the same way. But when you get somebody like Kosieradzki, and he talked about, the book, he mentioned the depositions book that Philip Miller and Paul Scopter, our late friend Paul Scopter, did,
yep.
Advanced deposition techniques. When you get Kos and Philip and Paul writing books, that is valuable stuff. I know whenever I teach with any of those guys, and they're the heads of the programs, they are militant about making sure that you're not up there telling more stories. Your PowerPoint is high quality. Your materials are high quality. They really make sure that the education's top notch.
And I think that's important, right? And I think I expressed this concern earlier is that there's bountiful amount of information and advice out there. But I think that AAJ does a good job in saying, who are we going to have present at this CLE, and are they of the caliber that we expect? Are they of the quality that we expect? And having taught at one of these things, and I felt so honored to do so, just getting tips from O'Brien in the background afterwards of saying, hey, look, here's how you can clean this up. Here's how you can make your presentation more effective the next time. And it's not about, beating your chest or doing something great. It's about making sure that the people who are attending and paying good money to be there receive as much quality information as you can give.
Yeah, they're not, Chris is a spectacular example of it. They've been teaching with AAJ long enough. It's not about just teaching the people that are there getting the CLE. They're teaching the presenters, and they want to make sure that they want to offer their help to everybody, whether you're teaching the CLE or you're attending the CLE. It's such a great organization.
I mean, these are guys who are living and breathing, and this. These guys are living and breathing this. They're not just like doing this so that they can get their names out there or get some publicity or anything like that. These are guys who Chris was telling me about how him and Phil hashed out, this Miller mousetrap that we learned at the Depot College in an airport bar. And that's what they're doing, right? I mean, that's all they live, breathe, and eat this stuff.
Yeah. And then, you get the benefit of it, and we've started using 30B6 depositions. I guess we've been doing it for 10 years now. Well, after Mark's been teaching it, but because it took me that long to figure it out. But it's just such a valuable tool to really cut to the chase, get through all the objections you get in discovery. I'm tired of getting responses to written discovery, requests for production of documents where, there's 5 pages of objections at the front, and then you ask the question, and then 4 paragraphs about specific objections regarding that. And then you get a line saying, subject to all those objections, we don't have anything responsive.
Right. And that's not helpful, right? Because you don't even know what the objection is. And then you don't know if they actually have it, and they're just being obnoxious.
Yeah.
I've had people object to the definitions, object to the very first question that they have to respond to on like standard interrogatory. But, I've had one recently where I asked for policy manuals and guidelines, and the response was, this company has no such thing as a policy manual or guideline. And it's like, come on. I mean, I know you have something that everyone refers to when it comes to this specific issue.
Right.
And the 30B6, the way that Mark teaches it and then talks about it in his book, cuts right to the chase.
And I'm glad to see more judges sanctioning lawyers that don't comply with the rules and have these ridiculous objections. And it comes back down to, I saw, and I've used a clip actually in some of my CLEs of a lawyer at one point saying, obstruct everything. He's teaching a CLE, obstruct everything. Don't give anything. He's a medical malpractice lawyer. And he was like, don't turn over the medical chart if you don't have to, and then his point is that most plaintiffs lawyers don't actually do anything with it. They whine, they cry, they send nasty letters, but they never file the motion, and they don't actually push them. And until we just start, pushing on these, we're going to keep getting the same thing.
That's right. United we stand, particularly in the trial bar. We got a rising tide raises all boats, brother.
And one of the things that I've noticed here in the last several years is like with, confidentiality agreements, there for a long time, we couldn't win an argument on a protective order, and we couldn't go in and say, look, they're not entitled to protective orders. And I don't know what it's like, in Missouri, but in Kentucky, at least the federal court judges, they've started really coming down on protective orders, even agreed protective orders. And they're coming in and saying, look, you have to comply with the rule. And the rule is you have to show why these documents are entitled to protection. And, so many lawyers are still just agreeing to protective orders. And then what I've seen the defense lawyers do to get around that is, okay, the judges are going to push back on an agreed protective order. So what we're going to do is we're going to have a confidentiality agreement that is outside of the court so that, the judge doesn't know we're agreeing to keep these confidential. And I just think that's just wrong.
Yeah. Yeah, that's crazy. I think it just takes one or two people to come forward and say, we're willing to lose this argument before the judge. And it turns out that it's a win. And all of a sudden, everyone else says, hey, you know what? We're going to try this too. And I think it all goes back to, we have an adversarial system. It's based on everyone having the same equal access to the facts and information and evidence, and then just duking it out in court, presenting the best case that you can to the jury. When you've got the other side hiding everything that they possibly can, it undermines that system. We're trying to block in confidentiality that information. It's just not good for it. And some of these guys are just saying, enough's enough. We're going to take a shot at this. And like you said, some judges are actually saying, nope, we're not. We're not going to do that. We're not going to enforce this.
Yeah. And we've posted a lot more interviews this week. As you know, we do 3 a week. So there's some real good ones that we've posted, and I know we've got in the pipeline as well. But Mike, we want more contributors to the Lawyer Minds website, don't we?
Yes, we do. LawyerMinds.com, nominate. You click on the nominate your tab. You nominate yourself. If you want to nominate someone else, get their buy-in first. But go on there, nominate yourself for an interview, and we'll get some questions out to you. You can share the link on social media. It's going to be great publicity for you. But more importantly, you're going to share your experience with other lawyers around the country.
Mike, good chat. Hope to see you again soon.
Looking forward to it, Tad.
That wraps another episode of the official Lawyer Minds podcast. Please consider subscribing to the show wherever you listen to podcasts. Explore the other content Lawyer Minds has to offer and engage with us on social media. Your feedback on the show and ideas for future shows is always welcomed. See you next time.